And now it's my honor and privilege to welcome our keynote speaker, the Honorable Stuart Kyle Duncan of the U.S. Court of Appeals for the Fifth Circuit. He was appointed to that court nearly a year ago by President Trump. From 2008 to 2012, he directed appellate litigation for the state of Louisiana's Attorney General. He then served as general counsel of the Becket Fund for Religious Liberty until 2014, when he founded his own law firm. He previously was an assistant professor of law at the University of Mississippi as well. Given his uniquely distinguished career in public service, in public interest law, in academia, and in private practice, the Gray Center is grateful that he can join our discussion today. So please join me in welcoming Judge Duncan. Thanks, Judge.
Thank you. Thank you, Adam. I'm deeply grateful to be invited to address this conference on religion and the administrative state. My family and I used to live in Northern Virginia until very recently. We miss the area very much, and it's great to see so many good friends. I appreciate you all coming. I need not tell you how important this topic is. This conference itself is evidence of that. Most everyone seems to agree that a society like ours that is planted thick with rules and regulations presents ever-increasing occasion for conflicts between government and religious claims. So it's imperative that scholars like you and practitioners like you continue to grapple with these matters. Sorry, I'm going to just make sure that I don't go over. What I want to reflect on is how the Supreme Court, in some key cases, has addressed this intersection between religion and administrative activity. Some of these are recent cases, but some are not. These issues have been with us for a long time. And naturally, as a judge, I offer no views about current conflicts winding their way through the courts. Nor do I offer any views on ongoing disputes about the scope of the administrative state or the strength of any particular religious claim. Whatever your views on those matters, or whatever my views on those matters for that matter, we can all learn from how the Supreme Court has approached these kinds of disputes. For instance, how the court has dealt with conflicts between an agency's understanding of a religious claim and the religious claimant's understanding of his or her own religious claim. Or to what extent the court has been willing to defer to agency expertise in these kinds of cases. At the outset, I should note, as Adam suggested, this is a meaningful topic for me personally. As all of you know, because Adam just announced it, I litigated in this area when I was general counsel of Becket in D.C. some years ago. But what some of you may not know is that I litigated on the government side of some of these questions when I was at the Louisiana Department of Justice. I recall one case in particular, a RLUIPA case I litigated against Becket and the ACLU in the Fifth Circuit. It asked whether a prison warden could bar circulation of a religious newspaper from the Nation of Islam. Every issue of the newspaper on the back cover prominently called for racial separatism. And the warden, my client, feared that this was a dangerous idea to introduce into a Louisiana prison that continued to experience interracial violence. As the warden's lawyer, you can imagine my argument. I emphasize a discretion that prison administrators must have to weed out publications that, in their expert judgment, could lead to unrest. Justice Sotomayor would later make a similar point in a case called Holt v. Hobbs. She wrote, "In the dangerous prison environment, regulations and procedures are needed to maintain good order, security, and discipline." So as the warden's lawyer, I stressed deference to an administrator's expertise. And on the other side, Becket and the ACLU argued that the prisoner's religious rights should prevail. I lost, but now, over a decade later, I have completely gotten over it. Completely. On to my subject. The first point I want to make is obvious, but I think important for context. It is that this subject, the conflict, or the interaction, I should say, more than conflict, between religious liberty and regulation has been with us a great long time. Some may think this is only a recent phenomenon based on prominent cases like Hosanna Tabor or Hobby Lobby or Masterpiece Cake Shop. But it is instructive to look further back and see these same kinds of conflicts. And I've been sitting through some panels today, and we've already heard discussion of them. For example, numerous important cases involving state unemployment agencies, such as Sherbert or Hobby or Thomas, and of course Smith itself. And I'll say more about that in a second, but Professor Epps had some really great things to say about Smith as a religious, as an administrative case. Thought it was very interesting. Also, significant cases involving agency conflicts with Native American religious rights, such as Bowen versus Roy, in which before we had the Little Sisters of the Poor, we had Little Bird of the Snow, a Native American child who claimed that the government's use of a unique Social Security number to administer welfare benefits violated her religious rights by robbing her spirit. We also had Ling versus Northwest Indian Cemetery Protective Association, asking whether the building and timber operations of the Federal Forest Service violated the rights of Native American tribes on their sacred lands. Indeed, one of the most prominent civil rights cases ever decided by the Supreme Court, featuring both religious claims and speech claims, is its 1943 decision in West Virginia State Board of Education versus Barnett, involving, as you all know, the constitutionality of requiring school children to salute the flag. As the name of that case indicates, the challenge rule came from a resolution by the State Board of Education, requiring this flag salute in the public schools and providing that, quote, refusal to salute the flag be regarded as an act of insubordination, close quote. To be sure, these cases were not litigated or decided as administrative law cases as such. They do not, for instance, feature discussions of agency deference or the intricacies of the Administrative Procedure Act. They were decided as straightforward conflicts between law or regulation on the one hand and claims of religious liberty, be they constitutional or statutory, on the other. And yet, going back and reading through these cases, it's easy to see a dawning recognition by the justices that the increasing complexity of the administrative state might present special challenges for religious claims. For example, let's hear Justice Robert Jackson's opinion in Barnett. He wrote that the 14th Amendment, quote, protects the citizen against the state itself and all of its creatures, boards of education not accepted. He went on to say, these have, of course, important, delicate, and highly discretionary functions, but none that they may not perform within the limits of the Bill of Rights. Over 40 years after that, in her concurrence in Bowen, Native American case, Justice O'Connor echoed this same idea. She wrote, quote, even if the founding fathers did not live in a society with the broad range of benefits and complex programs that the federal government administers today, they constructed a society in which the Constitution placed express limits upon governmental actions limiting the freedoms of that society's members. The rise of the welfare state, Justice O'Connor wrote, was not the fall of the Free Exercise Clause. All of this gives new zest to some of the famous statements from Justice Jackson's Barnett opinion, an opinion that on rereading seems to contain about half of all of the go-to Supreme Court quotations. We all remember Justice Jackson's self-deprecating statement that, quote, the task of translating the majestic generalities of the Bill of Rights into the 20th century is, quote, one to disturb self-confidence. Something tells me Justice Jackson did not lack for self-confidence, but it was nice of him to say that for the rest of us judges. But in the same passage, he goes on to say, quote, we must translate these rights to a soil in which social advancements are increasingly sought through closer integration of society and through expanded and strengthened governmental controls. And keep in mind, he was writing this in 1943. In the same vein, one of the most quoted passages from Barnett gets a new zing. Now, we've heard this one 1,000 times. I cited it myself in briefs, and I'll probably cite it in an opinion next week. or quoted in an opinion next week, quote, "If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." Now, perhaps, we can better hear his reference to high or petty officials as embracing not only presidents, cabinet secretaries, governors, or mayors, but also members of state civil rights commissions and acting deputy assistant secretaries of federal agencies. I recognize that we have a deputy assistant secretary of a federal agency sitting here, and I mean no offense to you. I just thought it was a really nice long title. The larger point is, well before our present day, decades, over half a century before our present day, the justices themselves were alive to the pressures that a growing administrative state might place on claims of conscience. So the second point I want to address is somewhat more substantive than that. The point is this: looking back on these cases, I think one can fairly draw the conclusion that fairly consistently the Supreme Court has accepted claims of religious liberty in these administrative law cases at face value. What do I mean by that? The court has generally been careful about accepting the contours of religious liberty claim as presented by the claimant. Perhaps the most important reason the court has done this is, in a sense, self-protective, to prevent administrative agencies and the court itself from making religious or theological judgments about the claims, the religious claims that are brought before it. And as we'll see, this feeds into my third point, which I'll get to in a second, about the kind of deference to agency expertise that the Supreme Court has been willing to afford. But let me give some examples to flesh out this point about taking religious liberty claims at face value. And of course, we just heard a great discussion about the sincerity principle. I'm not saying that courts would accept any religious liberty claim, even if it was insincere. That's obviously not the law. But as an example, take Hosanna Tabor, a much more modern case, in which the court rejected the EEOC's understanding of what constitutes a minister, for purposes of the ministerial exception. The agency argued that, quote, "any ministerial exception should be limited to employees performing exclusively religious functions." Now, the Supreme Court was not kind to the agency's view. It called it extreme, and it doubted whether even the head of a religious congregation would even qualify under the agency's test. The point is the court was not going to allow the agency to second-guess a religious body's self-understanding of what constituted a minister, which in large part is a theological determination. Now, we just heard an excellent discussion on unionization in which some of the panelists were making the very cogent points that there are inevitably line-drawing determinations that courts have to make even in this area. And you had discussion in the various concurring opinions over what the limits of that line drawing were going to be. But the larger point remains is the court was alive to was cautious to the idea that it needed to accept the self-understanding of the religious organization about what a minister was. It couldn't allow the agency simply to define it essentially out of existence. Take another case, Hobby Lobby. A key issue in that case was whether the contraceptive mandate made business owners morally complicit in distributing certain drugs. The agency took the position that there should be no problem for the business owners. After all, as the court wrote summarizing the agency's position, quote, "providing the coverage would not itself result in the destruction of an embryo. That would occur only if an employee chose to take advantage of the coverage," end quote. The court, once again, was not kind to this agency position. The court reminded the agency that this question was actually, quote, "a difficult and important question of religion and moral philosophy," that is, the question of moral complicity. And the court cautioned that the agency and the court itself had no business addressing such a question. Again, this had the effect of removing from agency competence the contours of a religious claim. The court and the agency had to take a sincere religious claim for what it was, not what they would like it to be. One other example, and this is from an earlier case in which the religious claimant lost, at least in part, and that's Bowen versus Roy. Again, that was the claim of Little Bird of the Snow and her parents that the government's use of her Social Security number would rob her spirit. Now, I would venture to say that this claim sounds pretty obscure to many people. It certainly does to me. It's just not familiar as a way of thinking about religious claims. And yet, the court gave it the profoundest respect in its opinion, carefully setting out the exact parameters of the religious claim by the Native American child's parents. That is, that in her parents' view, the person of their child had to be kept unique. Her spirit had to be kept unique. And that was compromised by the uniqueness of the Social Security number as an identifier. And that led the parents to believe that technology was robbing their child of her spirit. Now, as I was reading back through this claim and thinking about my own views on the iPhone and my children, I actually felt a lot more affinity to this claim these days. But needless to say, it's not a familiar claim, and it required a great deal of explanation by the court. And the important thing, in my view, is that the court measured the strength of the government's interest against the claimant's religious belief as understood by the claimant. Now, to be sure, Little Bird of the Snow lost, at least in part. The court ruled that her religious claim could not control the government's own internal administrative processes in how it processed the benefits. But, and I admit the opinion is not as clear as one would like it to be on this point, but a careful reading of the various opinions in the case shows the justices were much more sympathetic to a distinct claim that Little Bird of the Snow was making, and that was whether the government could condition the receipt of welfare benefits on her parents obtaining a Social Security number. Now, I wouldn't say that the court has a clear holding on that issue. There were also some mootness issues about whether the child had actually already obtained a Social Security number, at least that the government had obtained one. But it's an interesting dichotomy in the case, and the different opinions of the justices very carefully distinguished between those two claims. On the one hand, internal government processes. On the other hand, the condition on receipt of benefits. All of this is to say, administrative agencies obviously must employ various experts to do their work, economists, chemists, sociologists, and the like. But it is hard to see how they could legitimately employ theologians to reach religious judgments about the impact of their regulations. To the contrary, in case after case, the Supreme Court has required agencies and courts to accept the sincere claims of religious liberty as understood by the claimant. And as many of you know, because I just heard the case discussed on the two panels, one of the key decisions here is Thomas versus Review Board, where the court refused to take sides in a religious dispute between Jehovah's Witnesses over whether it was permissible for them to work, for a Jehovah's Witness to work in a munitions factory. In applying this case in Hobby Lobby, and I heard the Deputy Assistant Secretary actually quote this, the court drew the lesson that, quote, "It is not for us to say that religious beliefs are mistaken or insubstantial." And I was going to say that goes for agencies as well, but the Deputy Assistant confirmed that that's part of the agency guidance. So I'm glad to know I'm right about that. That gets me to my third point. All of this has implications for the kind of deference to agency expertise the court has been willing to afford in these kinds of cases. Now, don't get me wrong. I know these are not Chevron cases. I know these are not our deference cases. I'm speaking by analogy. The lesson appears to be, quote, deference where deference is due, and this again is quoting Justice Sotomayor in Holt v. Hobbs. So, for example, in Holt v. Hobbs, the court unanimously recognized that state prison officials were entitled to considerable deference in how they run prisons. But in a case where a prison regulation impinged on an inmate's religious practice, here it was preventing a Muslim inmate from growing a 1/2-inch beard, deference came to an end. Indeed, not only did the court refuse to defer to the administrator's view on a religious matter, and that was whether the inmate had other opportunities to practice his faith, but the court also carefully scrutinized the administrator's judgment on the grooming regulation. The court found the prison's justifications for its beard regulation, quote, hard to take seriously. This is not to say that agency deference disappears in these kinds of religious liberty cases. As Justice Sotomayor said again, courts will give deference where deference is due. For instance, in Hobby Lobby, the court seemed at least open to accepting the agency's expertise on the tailoring question, meaning whether the government had other means of getting free contraceptives to women. And of course, as we all know, the court simply assumed the question of the compelling interest and didn't decide it, but presumably it would have been open to agency expertise on that issue as well. The problem with the tailoring point was that, at least in the court's view, the agency did not meet its evidentiary burden to show other means, or to show that this was the least restrictive means. As another point about the limits of agency deference in these kind of cases, the court has been wary of the possibility that an agency is preferring secular reasons over religious reasons in refusing to accommodate religious claims. Holt, again, is a good example. The court was skeptical about the prison grooming regulation because it made exceptions for medical conditions, but not for religious reasons. And this kind of reasoning assumed even greater prominence in the recent Masterpiece Cake Shop case, and we heard a great discussion of that during the first panel. Just in case someone hasn't heard of that case, it involved whether a state civil rights commission properly penalized a baker for refusing to design a wedding cake for a same-sex marriage. The court carefully scrutinized the state administrative record and determined that some commissioners had made disparaging comments about the baker's religious claims. The court was also skeptical because the commission had allowed other bakers to refuse to make cakes with anti-same-sex marriage messages. The court reasoned that this showed the commission was making judgments about the relative offensiveness of the two competing messages and thus failed to be neutral to the baker's free exercise claims. Now, I fully recognize there is a very interesting discussion going on in the concurrences in that case between Justice Kagan on the one hand and Justice Gorsuch on the other. That has to do with the limits of deference as they understand it to the state administrative agency's determination. And naturally, I have nothing to say about that, it being something for future cases. Now, the final point I want to make is perhaps the most obvious. You know, when you're a sitting circuit judge and you're asked to give a talk at on a really explosive topic, you try to say really obvious things. So the last and most obvious thing I would say is in the interplay between religious liberty claims and administrative agencies, the courts will continue, surely, to play a key role. That was the gist of Justice Jackson's statements from Barnett so many years ago about applying the 18th century Bill of Rights in a modern society with expanded and strengthened governmental controls. That was Justice O'Connor's point in Bowen when she said the rise of the welfare state was not the fall of the free exercise clause. In her view, the courts would ultimately be the ones to determine whether the claims of the little bird of the snow would or would not prevail against what she called the, quote, unanchored anxieties of the welfare bureaucracy. But I end with a more recent statement on this point, and this is from Justice Kennedy's concurrence in Hobby Lobby. He wrote that the free exercise of religion is, quote, essential in preserving one's dignity and in striving for a self-definition shaped by one's religious precepts, end quote. But at the same time, Justice Kennedy cautioned that, quote, in a complex society, in an era of pervasive governmental regulation, defining the proper realm for free exercise can be difficult. Indeed, it can. But I think the history of the Supreme Court's activity in this area should give us cause for optimism. Yes, an increasingly complex regulatory state presents increasingly complex problems for religious claims, but the Supreme Court has marked out, at least in broad outlines, a path for reconciling the two in a constructive way. This is a path that can be followed both by courts and by agencies. And we've seen a representative from an agency talk about the kinds of guidance that the agency is developing on these questions. It would be a happy resolution consistent with our law's commitment to individual freedom if in another 20 or 50 years we could say that the administrative state, no matter what form we find it in, provides a forum for the just and sensitive accommodation of claims of religious liberty. Then we could all say confidently with Justice O'Connor that the rise of the administrative state was not the fall of free exercise. I want to express again my profound gratitude to Scalia Law School, to George Mason, and to the Boyd and Gray Center for inviting me to this conference. It's a delight to be with all of you. I congratulate you on the important work that you're doing and hope that you will continue to do it. Thank you.